liable for GBH. That sort of, that's grievous bodily harm is an injury. So you've got to give it the proper title. It might be, sort of assault or battery occasioning actual bodily harm, and you can give the statutory provision. But you wouldn't just say is liable for GBH or ABH or whatever. So we've got to be more precise than that. Then we look at the elements of the actus reus. So for murder, we already know that the actus reus is unlawful killing of a human creature in being under the Queen's peace. So we'll look later at how we arrive at that. So everybody in Monday's tutorial could cite that. So make sure that you've got these sort of shorthand definitions of the actus reus, mens rea, of the various offences. And we will go through the actus reus elements, and for example, theft, statutory offence, has 5 elements: dishonest, appropriation, property belonging to another, intention to permanently deprive the owner of it. Well, the actus reus elements are the middle 3 elements: appropriation, property belonging to another, 3. Okay, so we would talk about or elaborate about the elements that are problematic, and skate over the non-contentious ones. So you've got to elaborate on the actus reus elements at issue. So that's the second point. And give authorities. Might be case law or statute. So remember, you must give authorities. The third is, once we've got the actus reus sorted out, and remember, causation issues are related to the actus reus because as a sort of prerequisite, it's necessary for the prosecution to brought about the actus reus, and there's no causation issues. So causation is normally associated with result crimes. So this is where something might happen between the infliction of wrongful injury and then the prohibited result. So in between time something happens and there's a problem. So actus reus issues stroke causation. Then the third stage is mens rea, or the fault element. So we know there are 2 basic types of mens rea, and of course some crimes don't need mens rea, strict liability offence. Most of the crimes we come across will require mens rea. So what are the 2 basic kinds of mens rea? For okay, intention. Okay, and the other kind of mens rea, which might be possible for involuntary manslaughter, will be recklessness. Okay, so intention or recklessness. Now, criminal damage, for example, can be committed intentionally or recklessly. Now, okay, there are a couple of kinds of criminal damage. The provisions in the Criminal Damage Act 1971 where intention only is required. Certain modes of criminal damage, but we'll put that to one side at the moment. Okay, so the next point is where facts do not permit a conclusive answer. What I call grey facts, could be this, could be that. You need to acknowledge this in your answer and give your best evaluative conclusion. Now, normally this is where you're in the position of the jury. Now, some lecturers say you shouldn't really try to predict what the jury will decide, because you can't, because you haven't got a crystal ball, you don't know. But I would say you just apply the most reasonable interpretation, and you give some indication of how you think this might be decided, but without expending a lot of time and energy, because it doesn't really get you anywhere, because we're not actually in a real life situation. So if you're not sure, you can say, well, it could go this way or it could go that way, but you have to sort of evaluate, give your best evaluative conclusion. Okay, so the fourth stage will be you've got your actus reus, you've got some fault element, so then you have to consider whether there are any defences. So we haven't done defences yet, but there are a number of defences that might arise. So duress, self-defence, insanity, now loss of control or diminished responsibility. But remember, some of these defences are not applicable to certain offences. For example, we've already mentioned that loss of control, diminished responsibility are partial defences and they only apply to murder. Duress as well. So the duress can be duress by threats or duress of circumstances. So this is, where you're basically the defendant's pleading some sort of coercion. Again, this cannot be pleaded to murder, so that defence is restricted in scope. But self-defence, insanity are broader defences, and they can be pleaded to, say, murder. In fact, I had a case once where insanity was pleaded to theft in the magistrate's court, and I was the prosecutor, and I was advising the defendant to go and see a solicitor because I didn't think it was a good idea for this person to plead insanity. Well, when we do insanity, we'll explain why this might not be a good idea. So very few people plead insanity now. Okay, so defences. I think I've mentioned in the lectures that defences sometimes, are not like true defences. Like self-defence is really arguing that the conduct is justified and that it is not, it's a defect of the actus reus, and insanity is perhaps a defect of the mens rea, whereas duress is said to be a true defence. It's said to be a defence of, say, confession and avoidance, that you actually confess the elements of the offence, but you put forward a good excuse for, escaping liability. That somebody coerced you to do this. So generally with defences, we say, oh, right, plead the most viable first, as you would in real life in a court situation. So if we roll back to when we consider the offences, as a general rule, we might say, well, you should start with the more serious ones first, because that would be of practical advantage in real life. But sometimes it depends on how you choose to answer your question, because if you're answering your question in the chronology of the facts, the narrative, if you like, then you're not going to do it that way. So I don't say that there's any hard and fast rule about which offences you deal with, but 99% of the time for defences you would start with the most viable first, and just like your offences, you need to define the elements of the offence and give the source authority. So, for example, for loss of control, diminished responsibility, then we would need to look at Section 2 of the Homicide Act 1957, which has been amended and substituted by the Coroners and Justice Act 2009. Now, sometimes in relation to defences, we need to make a point about the burden of proof. Most of the time, the burden of proof remains with the prosecution to disprove the defence beyond reasonable doubt. Now, sometimes the defendant will be expected to bear some sort of evidential burden to raise some facts of the defence, but there are two important exceptions to that. One is insanity, and the other is diminished responsibility. In both those cases where we've got to sort of look at the defendant's sort of psychological situation, if you like, then the burden of proof is borne by the defendant themselves. but of course, as you'll know, the standard is lower on the balance of probability. Okay, so we'd need to make that clear as well. And then finally, we would give some sort of formal global summing up concluding paragraph that would refer back to the question. So that would make it look a more stylish answer. Okay, so those are the basic stages we would go through. I think you've looked at this problem-solving formula previously. So identify legal issues, define legal concepts like, you know, unlawful killing or dishonesty or intention to permanently deprive, whatever it is. Explain relevant law, citing the authorities, apply to the facts. So the stages D, E, A, you know, we might be going through a number of times depending on the points and issues we've picked out in the problem. And you know, and each time you go through it, D, E, A, then you come to some sort of sub-conclusion, and then at the end you will give some sort of overall conclusion. Okay, so as far as our problem is concerned, then we need to review homicide offences, this global label for murder, manslaughter, types of scenarios. In this particular problem, which of the victims plus causation. So we deal in this case with causation as a preliminary issue, I would recommend, a bit like in tort when you dealt with causation as a preliminary issue for a number of victims or claims, if you like, and then you dealt with individually remoteness of damage, etc., you know, breach and remoteness of damage. So here we'd have because murder and manslaughter, in this case we're focusing on involuntary manslaughter, you know, the common theme is unlawful killing. We can deal with that to begin with, and we can see whether Chris has brought about the unlawful killing, the actus reus, vis-a-vis each of the victims involved in the case. So if we decide that yes, he is responsible for the unlawful killings of each of the victims, then we can move on to the mens rea stage for each of those victims and separate things out. And then we could consider defences. But because of the limitation in the question, this is not part of your answer. And as I said before, any slides on that would be for reference only. Okay, so we've already mentioned all the victims, Duquan, Idris, Kima, Wendy and Rob. And we have to look to see whether, you know, there is unlawful killing and whether there is murder or manslaughter. So I assume that we can, we know the actus reus of unlawful killing. So remember, it comes from this traditional source from Lord Chief Justice Cook, spelt Coke. So when a man of sound memory, meaning he's you know, sort of not mad, at the age of discretion, he's the age of criminal responsibility, unlawfully kill within the jurisdiction any reasonable creature in rerum natura, a human creature in being, under the king's peace would now be the queen's peace, with malice aforethought. Now we shouldn't use this label malice aforethought. We should use the correct definition as stated in the case law: intention to kill or intention to cause grievous bodily harm. The last part of it in square brackets is the year and a day rule. So as the party wounded or hurt die of the wound or hurt within a year of the date, that is no longer good law. In 1996, I think it was abrogated. Okay, so that's Cook, Lord Chief Justice. You had that in your lectures. Okay, so now we would paraphrase it like that, and of course that the actus reus part of it will be the actus reus for murder and manslaughter. and intention to kill or intention to cause serious bodily harm or grievous bodily harm, but really the more recent cases refer to serious bodily harm. Grievous bodily harm is, you know, sort of from Victorian statutes and things, so an old-fashioned law, but people still look at it. Okay, in relation to the slides, at the end of the tutorial cycle, these slides will go on the SOL system. Okay. So 1996, year and a day were all abrogated. So after stating the homicide offences that we're considering and the actus reus, so let's think about the first victim, Duquan. So Chris approaches Duquan's house, finds a brick lying outside, which he picks up and throws through the window, and the brick it flies through the window and hits Duquan on the head. Now, because of the preceding paragraph, it looks as if Chris didn't intend to kill Duquan, because it says the gang member, Chris decides to cause damage to the ground as if there was actually purposive intention to kill. We've got this unlawful killing, and we might consider murder, but you know, there may be a problem with that. So let's say, for argument's sake, well, let's, you know, murder, unlawful killing. So after the wrongful act, the throwing of the brick, but before we consider the sort of mens rea issues, we've got to make sure that we've got causation. So we have to show that Chris is responsible for the bringing about of the actus reus. And so we know that there are factual causation. Taught you came across the test for factual causation. What is the test for factual causation in criminal law? Okay, the but-for test, very good. Yeah, okay, so, you know, would Duquan have died but for the actions of Chris? Well, the answer is no. And, you know, in most of your questions in the exam, the but-for test is not going to be a problem, because, you know, otherwise you'd have a very short answer. So here, we need to give an authority. So what would the authority be in criminal law? Who was the loving son who gave his mother a bedtime drink with poison in it, with cyanide in it? But she didn't drink it, or there was no evidence that she'd drunk it, and she died in the night. Remember that case? Yes? Okay, not black, but the opposite. White. Okay, so the but-for test and White. So White's mother would not have died but for the actions. Sorry, would have died anyway. So the loving son's you know, poisoning of the drink was not a but-for cause of mother's death. So there, the son was liable for attempted murder, but not murder itself, because you know, the causation issue was not established. Okay, so again, we can apply the but-for test in each case, and in each case there doesn't seem to be a problem from our point of view. Okay, so we'll skate over that a little bit. legal causation. So here we've got to look at the legal tests, the legal causation tests. And these are sort of common law tests, a bit like, the tests in tort, where, there are similarities because criminal law is an offspring, an offshoot of tort. So the common law test, they try to select who should be legally responsible, not just factually responsible, or that that there's some sort of factual link, and require that the defendant's actions have some proximity, or they are beyond the de minimis range of contribution. So if we have some wrongdoing, then there can be a number of competing causes, and the defendant's cause needs to be a more than minimal cause, a more substantial cause. Plus, there's another rule that says that the cause needs to be a significant and operating cause of death. So it still needs to be of some influence over the victim's death. So here, the de minimis rule, so CATO, so we just have to remember that, and then significant and operating cause of death, well, that's the so-called Smith principle. So there are two leading cases that we need to cite. So the Smith case, and that will be the most often required case, because and it was confirmed in Cheshire. Okay, so if we remind ourselves what happened in Smith, so the defendant in Smith was a soldier, and he had a gun, a rifle, with a bayonet on the end, a sort of knife thing on the end. And one Saturday night, when the soldiers had been drinking in the barracks, there was some sort of dispute, and the defendant got his rifle out with the bayonet, and he stabbed his brother soldier and pierced his lung, and wounded him. So the other soldiers who were, had been drinking alcohol and had been fighting as well, well, they did their bit and they tried to help the injured person, and they carried the injured person to the medical station, so the military medical station. Unfortunately, because they'd been drinking alcohol, they dropped the guy, a couple of times on the way, so that didn't help. And then when the victim got to the medical station, he was treated by the medical officer, but the medical officer, because he was completely overworked and overrun with lots of injuries from these fighting soldiers, he failed to realize how seriously injured the victim was, and that the wound was deep and had actually pierced the victim's lung. So he gave him the completely wrong sorts of treatment, and he gave him lots of fluids, and the fluids sort of filled up his lungs, and and so he died. The victim died 2 or 3 hours later. So here the defendant tried to argue that he wasn't responsible for the actus reus, the unlawful killing of the victim soldier, that it was the medical officer's bad medical treatment that intervened and broke the chain of causation. But it was held in this case that the original wound was still operational, still influential, and it was still a significant and operating cause. Wrongdoer would not be relieved of liability, because remember, if the chain of causation is broken, there's no actus reus, there can be no crime, and then the original wrongdoer will escape liability. Okay, so that approach confirmed in Cheshire. We'll mention Cheshire a little bit later. So yeah, on a more general note, that the acts of the defendant need not be the sole cause or even the main cause of the victim's death, but it's sufficient that the defendant's acts contributed more than minimally. And that, of course, is possible to have a number of competing causes, including maltreating doctors or medical staff. So, so here, the original wrongdoing is still the operating cause, still relevant and influential. There's no novus actus interveniens, intervening act or event. Okay, so generally, a novus actus interveniens will be some sort of abnormal or unforeseeable act or event or omission, either by or ambulance staff, or the victim themselves. They don't look after themselves properly, or they don't seek medical treatment, or maybe they refuse medical treatment for various reasons, or maybe because of their injuries they might commit suicide, or maybe they can't commit suicide, they're not physically capable of committing suicide, or they go for assisted euthanasia, say in Belgium, where euthanasia is lawful, but not in England and Wales. Of course, that would have to be, usually have to be with some sort of assistance. So we've got to look to see whether there's some sort of intervening act or event that occurs after the defendant's original wrongdoing, but before the victim's death, if we're dealing with unlawful killing as the actus reus. Do remember that these principles of causation apply to all result crimes. But if the novus actus interveniens is so significant and so extraordinary that it makes the actions of the original wrongdoer, the defendant, part of history or the background or the context of the prohibited result, then it's no longer a cause of it. So this is the approach, the causation approach that we need to apply. Okay, so these are all our 5 victims, but causation issues are only applicable to the first 4 because Rob, the essential issue is whether there's murder, where Chris stamps on Rob's head while he's lying on the floor. So I know there's some sort of aggravation, and Rob runs out of the pub to escape, and then outside Rob trips falling over the pavement and is lying on the floor. So okay, there might be a causation issue there in terms of escaping victims, but then the situation moves on and Chris stamps on the victim's head several times. So there's no real causation issue, that the action of stamping on the head and then that causes death. So there's no interval and time between what happens. So the causation issues that we're discussing will be in relation to the first 4 victims. Okay, so let's start with the first victim, Duquan. So factual causation easily established. So Duquan would not have died but for the actions of Chris. So Chris is a but-for cause of Duquan's death. Apply the case of White, no problem. Legal causation, well, I think this can be established as well, because Chris's act appears to be, a more than de minimis cause, certainly, and it's a substantial and operating cause of the victim's death. So we apply the Smith principle here, because it's a little bit like Smith, because Smith, the victim died, just a few hours later. So the Smith principle applies there. However, there is, a complicating feature. Okay, so this is repeating some of the approach we said before. However, there is a complicating feature. Duquan has a pre-existing sensitivity or condition, because there's reference to what's it called, a latent condition which leaves him with weakened blood vessels. What do we mean by a latent condition? Okay. Yeah, very good. Some sort of unknown or hidden condition. So you should have come across that term in tort. Was it Smith and Leach brain, if I remember that? So that was a latent condition, a latent cancer or whatever. So thin skull rule or eggshell skull rule, I don't mind what you call it, needs to be applied. So we can illustrate this point by either the case of Hayward. I would prefer you to use the case of Blau. So Hayward was the bad-tempered husband who was chasing his wife and threatening her and shaking his fist, and the poor woman, he was running away in fright and fell down the stairs, and she and then was kicked by her husband. So then, because of a pre-existing heart problem, she had a heart attack and died, and so there the husband was held to be liable. So that case sort of illustrates escaping victims as well. But the case I would prefer you to use is the case of Blau. So it's more recent, and also it really expands the principle, and we've got quite a good good quotation from Lawton LJ that we should use, and we should cite his name. So in Blau, the defendant stabbed a young girl, piercing her lung, and the girl was taken off to hospital, where she was told that she would need a blood transfusion if she was to survive, and that if she did have a blood transfusion, then she had an 80-something% chance of living. But the girl, because of her religious beliefs, refused the life-saving medical treatment, a blood transfusion, because she was a Jehovah's Witness, and it was against her religion to accept the blood of another person, in her body. So brave girl, really. She knew the consequences, and she died. So medical evidence was established that she would have survived. So if you like, the defendant is the stabber, and then he sets off a sort of chain of causation, like a flow of causation. And, basically we could say in this situation, the girl is, refusing the life-saving medical treatment. So she's refusing to interrupt the flow, if you like. She's just letting the natural consequences of what the defendant does, occur. So here, the defendant, he argued, it's not my fault that the victim died. It's her own fault. She should have, accepted the life-saving medical treatment, and she would have been fine. So, her refusal is a novus actus interveniens. But the court did not agree, and Lawton LJ stated that the rule was that the defendant must take his victim as he finds him. So this had been a maxim in the common law for a long, long time. But he makes it quite clear that, he finds him in body and in mind. So any pre-existing condition of the victim, either physical or psychological, will not break the chain of causation. But what's important in this case is to say, under the sort of the mental category, if you like, psychological category, religious beliefs are, put in there. So this approach is confirmed in the case of Deer, and then we might also see some sort of confirmation of this in the case of Wallace, Berliner Wallace. So this was the defendant who threw acid over her, former partner in a jealous rage, and the victim was so severely disfigured and in such terrible pain that with assistance he was able to travel to Belgium, and then he you know, had arranged for voluntary euthanasia, so euthanasia via medical assistance. So here, Wallace, Berliner Wallace tried to argue at trial that there was no case to answer, and that submission was successful, but the prosecution appealed against that. And on appeal, Court of Appeal said no, the issue should have gone to the jury. Now, whether they would have, found that or not, well, actually, on retrial, the Court of Appeal submitted the case for retrial, and actually they didn't, they said that the chain of causation, had been broken on the particular evidence, but the approach, the initial appellate court hearing was confirmed, the Blau approach in Wallace Berliner. Okay, so here basically we would apply the Blau case, and Chris is likely to be the legal cause of Duquan's death. Now, a good answer would say, look, there is a factual distinction between the question scenario and the facts of Blau, because obviously in Duquan he suffers from a latent physical condition, but in Blau itself we're talking about religious beliefs and a psychological pre-existing sensitivity. Does this make a difference? Well, if we strictly apply Lawton LJ's quotation, then it won't make a difference, and this is why Blau is a good case to cite, and you can make this factual distinction. So here we've defined the issues that we're talking about, explained the relevant law, apply the law to the facts. So if we say the actus reus is established here, that would be our sub-conclusion. Then we can move on to the next stage, the mens rea. However, because we want to be efficient in the exam, I would recommend, and you don't have to do this, that you deal with all the causation issues vis-a-vis each of the victims as a precondition, if you like. And you did this in tort when you dealt with breach and remoteness of damage. So any causation issue would have to be a sort of precondition. Okay, so here, is Chris a but-for cause of chemo and Idris's death? Well, yes, we know that that's going to be straightforward. But what about legal causation in both those cases? So with chemo, well, there appears to be, no problem with legal causation there. But what about Idris as an escaping victim scenario? So we might need to talk about escaping victim cases. So with chemo, that would be straightforward. So we could apply Smith-Cheshire. So, the original wrongdoing will still be a substantial and operative cause of the victim's death. But in relation to Idris's death here, so the second case, Roberts, and here, we've got the reaction of the victim to the harmful conduct of the defendant. And, as long as the reaction of the victim is sort of sensible, if you like, and not daft or stupid and unforeseeable, then cases like Roberts and Williams and Davis say that unless the actions of the victims in escaping are daft and therefore unforeseeable, they will not break the chain of causation. So if we remember in Roberts, the defendant was the driver of a car, and he'd been to some sort of party or festival, I think, and he offered a girl a ride home in the car, and she accepted, but during the course of the journey she became frightened because he was sexually assaulting her, removing her clothes, and so she made the decision to escape that harmful situation, and she jumped out of the car while the car was still moving and was injured. She sustained actual bodily harm. So we'll see in relation to non-fatal offences against the person that would be section 47 of the Offences Against the Person Act 1861. So causing assault occasioning actual bodily harm. So the victim in Roberts did not die, but the defendant, when he argued, well, it's not my fault that the victim injured herself, it was her own fault for jumping out of the car while we're still moving along. So it was held that unless the actions of the victim in escaping are so daft or stupid, therefore unforeseeable, they will not break the chain of causation. So the defendant was still liable for the victim's wrongdoing. So that's one escaping victim case. But the one I particularly like to use is Williams and Davis. So Williams and Davis just sort of fine tunes the sort of test a little bit. So Williams and Davis, facts very similar, except in this situation, two defendants in the car, and the victim was a hitchhiker. And so here, when he realized he was going to be robbed, he made the fateful decision to jump out of the car while the car was still moving. So here, the question before the court was whether it was foreseeable that some harm, albeit not serious harm, was likely to result from the threat or the wrongful conduct. So in this case, when the victim jumped out of the car while it was still moving, this victim jumped to his death. So here the issue was unlawful act manslaughter. So it had to be foreseeable that some harm, albeit not serious harm, would result. Okay, so that was one issue. And then the second issue is the one that we're particularly interested in. The question was whether the reaction of the victim was within the range of responses that might be expected of a victim in a victim's situation. So in other words, was the reaction of the victim sort of reasonable in the circumstances, like imposing a reasonableness test? So within the range of responses that might be expected from a victim in that situation. But bearing in mind the victim was acting in the agony of the moment. So agony of the moment, it sounds quite dramatic, but we see that phrase in relation to self-defense. And this is where a victim has to, make their mind up instantaneously, an instinctive reaction, and they don't have the luxury of time to think, oh, well, if the driver slows down at the traffic lights, for example, then it might be safer for me to jump out then. So, there isn't that luxury at the time. I've got to make a sort of there and then decision, the agony of the moment. So here, in relation to Kima, but for Tess, no problem, and then the roof falling down, killing her, well, there's no novus actus interveniens. It's all very foreseeable result of setting fire. That's not so that Chris's actions are still a substantial and operating cause of Kima's death. So we apply the Smith principle confirmed by Cheshire there. But in relation to Idris, we'd make the point, the but-for test easily established, and that Idris's escape is a reasonable reaction within the range of responses, not daft. So the chain of causation is not broken. And again, we would apply the approach in Williams and Davis. Okay, so we've got Duquan, Idris, and Kima, but what about Wendy? So still on causation issues. So factual causation, well, Wendy would not have died but for Chris being on the road, etc., not paying attention. But what about legal causation? The car crash, is it more the minimal cause of Wendy's death? Yes, of course. And what about the bad medical treatment? Because we are told in the question, at the hospital, Wendy is treated by an overworked junior doctor who does not notice that alongside her leg injuries, Wendy has ruptured her spleen, and as a result, this is not treated. So Wendy's condition deteriorates, and she's transferred to an intensive care unit, and basically she doesn't actually get out of there. As she's moved, she's dropped on the floor by the hospital porters. So of course that's a bit like the facts in Smith. So we need to have a look at the issues. Okay, so we're going to have a look at the case law. Right, and another question about the slides. So at the end of the tutorial sequence, then these slides will go on the SOL system. I think this should have happened last year, so that's exactly the same this year. Okay, so we look at Smith and Cheshire. So here we could compare those cases if we want a more sophisticated answer with a case called Jordan. Now, Jordan is a strange case in some ways. So the defendant Jordan stabbed the victim. Victim went to hospital, had the stab wound treated. I think maybe was stitched up, etc. And the victim was almost healed, and the stab wound was almost healed. And then the victim died. Now at trial, there didn't seem to be any evidence of any other cause of death other than the stab wound, and so Jordan was convicted of manslaughter. But then two doctors came forward and reported that the victim in the hospital had received bad medical treatment, that he had received an antibiotic that he'd shown an intolerance to, and then a few days later, for whatever reason, maybe the reaction, the intolerance had not been recorded correctly on the medical notes, he was given the same antibiotic, and of course the second time round the reaction is always stronger, and the victim died. So here, what's peculiar about the case is that, of course, the defendant, when he heard about this bad medical treatment, he appealed against the decision, and then in the appellate court, these two doctors gave the fresh evidence. Well, normally the Court of Appeal would not hear such evidence. The case should really have been remitted back to the Court of First Instance, the Crown Court, for a rehearing, but that didn't happen. Maybe in 1956, the sort of procedure a bit more peculiar. So here, this decision is widely criticised because the Court of Appeal held that the medical treatment has to be palpably wrong to break the chain of causation, and this did seem to be palpably wrong medical treatment. But the case was, criticised, and later cases seem to say that the decision is widely regarded as confined to its own facts, meaning, later courts don't like that decision. But here we can distinguish Jordan in any event, because we don't have a factual scenario where Wendy's getting so much better that her injuries are almost healed. She doesn't get out of the intensive care unit, so Jordan is distinguishable on the facts, and so we would apply the Smith principle that at the time of the death, is not long after the injuries were inflicted, and of course Wendy's suffering from multiple injuries, that the um, the injuries, the wrongdoing is still a substantial and operating cause of the victim's death. And we can sort of cite something that was said in Smith, that medical negligence is a fact of life and as such is foreseeable. So in all but the very worst cases, bad medical treatment will not break the chain of causation. And then we see this approach reinforced in Cheshire. Okay, so and Cheshire, let's go back. Cheshire itself was factually a bit more like Jordan. So in Cheshire, the defendant was went to a fish and chip shop, and there was a queue, and there was some dispute in the queue, and the defendant, who was a nasty person, took out his gun and he shot the person in front in the queue in the stomach and in the thigh. And so the victim went to hospital and was treated, and the gunshot wounds, had almost healed. But the victim had been given a tracheotomy operation, so a windpipe operation, and the medical treatment, the nursing care to keep the airway clean and free of sort of any blockage wasn't done. And so in that case there was quite bad medical treatment, but even so the Court of Appeal said only in the most extraordinary and unusual circumstances, where the second sort of wrongdoing is so independent and so potent of the first one, will the chain of causation be broken. So in Cheshire itself, the chain of causation was held not to be broken by that particular bad medical treatment. So Chris is still likely to be regarded as the legal cause of Wendy's death. Jordan can be easily distinguished. And very important to note the sort of policy cumulative effect of Smith and Cheshire is that negligence by medical practitioners will almost never break the chain of causation. So only in the most extraordinary and unusual cases. So you look at Lord Justice Beldham's judgment in the case of Cheshire. It'll be irrelevant most of the time that medical staff were negligent or even reckless. But it could be other third parties, like I think there was one example in an exam that the hospital cleaner had unplugged the sort of ventilator machine, and so the victim died as a result. So the cleaner wanted to plug in the vacuum cleaner or something. So there, it might not be bad medical treatment, it might be intervention by another party. Okay, so the last victim, so Chris stamping on Rob's head doesn't seem to disclose factual legal causation, although we did have a sort of escaping victim issue slightly beforehand, but at the actual cause of death is a stamping on the head. So I think we don't need to be sidetracked about the escaping victim scenario. So in Rob's case, we could move potentially to a murder scenario and consider whether there was intention to kill, or at least intention to cause serious bodily harm, which I think there is if he's stamping on the victim's head while the victim is on the ground. Okay, so Rob there, pretty straightforward. Okay, so moving on to mens rea issues. So in relation to Duquan, does Chris have the mens rea for the murder of Duquan, and what about Idris and Kima? So let's just think about here. So if we haven't done so already, we would need to give the mens rea for murder. So, intention to kill or intention to cause grievous bodily harm plus an authority. Do not use the well-worn phrases malice aforethought, because that's old hat and no good. You won't get the marks for that. So what would an authority be for intention to kill or intention to cause grievous bodily harm as the mens rea for murder? Okay, well, we've got a choice. So you could have Cunningham 1982 or Maloney, or we could have Ned Woolin would be another good one. So, and we need to know the difference between direct intention and indirect intention. So, as I mentioned before, it doesn't look like this is a direct intention scenario. Oh, that should say direct intention. I better change that. Sorry, direction. I'm sorry. Okay. Right. So Maloney then explain the golden rule, how it applies. So here, he throws the brick, and it looks like his direct intention is to cause damage. But of course, we may consider that this is an example of indirect intention. So, well, this is difficult to decide. So this is one of these ambiguous situations, and where we've got grey facts. So, we don't know how far away he is, and whether, because he throws the brick, whether it's almost an inevitable byproduct of what he does, that somebody might be hit on the head with the brick. So we would have to apply the indirect intention scenarios in these cases. So Maloney, Hancock and Shanklin, Woolin, as interpreted in Matthews and Elaine. So you really need to look at these cases and have and be clear about the test. So here we focus on Woolin and the test in Woolin. So it depends on whether the prohibited result, the death or serious bodily harm, would be a virtually certain result of Chris's actions, and plus, did Chris realise that the prohibited result would be a virtually certain consequence of his actions? Now, so those are the questions that the jury would have to consider, and if the answer to that is yes, then the jury may find intention. Okay, now the difference between the Nedrick approach and the Woolin approach is just one word. So in Nedrick, the court said may infer intention, and then in Woolin, Lord Stein said may find intention. So it wasn't clear whether there was a change made by Woolin, that the jury, could infer the intention from the facts that they'd found, or they had to find intention. So, if they answered the questions yes, then that was a definitional test, a legal definitional test, as opposed to, oh, right, then we can use that as evidence and infer intention. So, in other words, as some academics have put it, did the jury retain their sort of moral sort of elbow room? Could they not infer it if they wanted to get out of it, and not convict a defendant of murder? And so this issue was considered in Matthews and Elaine, and it was held that, despite the change in one word, that the effect was still the same, that the jury may infer intention, even though it may find intention. They don't have to. So the test is still evidential in approach, not definitional. Okay, so here, um, depending on the precise facts, we're not sure. It's arguable whether Chris would have the mens rea for murder. So it would be prudent to consider a viable alternative. So, in your answers, you've got to focus on what's viable and reasonable and not just completely speculative. So here, the viable alternative is unlawful and dangerous act manslaughter. And this would be the most likely successful crime here. So, so if Chris did not intend death or serious personal harm, then consider so-called constructive manslaughter or unlawful and dangerous act manslaughter. So if we're looking at this, then a good case to use to structure your answer is Attorney General's reference number 3 of 1994, and this is because Lord Hope gave 4 requirements. So he didn't really invent any new law as far as unlawful act manslaughter is concerned, but he set it out nicely. So this is why we might use it. So we can actually amplify this approach as well. So firstly, we have to look to see whether Chris, the defendant, did an intentional act. Now, in this context, it means a deliberate act. It wasn't sort of like accidental or coerced or something like that. Secondly, the defendant must have been doing some sort of unlawful act, and it's got to be a criminally unlawful act. It can't just be a tortious unlawful act or any other sort of unlawful act. So here, an authority, a good authority, would be the case of Lamb to illustrate unlawfulness, because in Lamb, the sort of the act that the prosecution put forward was not actually unlawful, because in Lamb the defendant was holding a gun and he was messing around, and he was pointing it as his friend, but both were treating this as a sort of prank, which turned out to be a dangerous prank. And so he pointed the gun at the friend. He'd already looked down the barrel of the gun to see whether there was a bullet. No bullet. So he pointed it and he squeezed the trigger. And what happened when he squeezed the trigger was that the cylinder on the gun, it was like one of those sort of cowboys and Indians guns with a rotating cylinder, or Russian roulette guns, where the cylinder rotates and puts a bullet in line with the barrel. And once you fully pull the trigger, then the bullet is fired. Now, this killed the friend, but the friend, hadn't expected this at all either. He thought there was no bullet, so they couldn't see a bullet, so he wasn't frightened at all. So the prosecution was alleging that the criminally unlawful act was common assault, but the victim wasn't in fear of then and there being subjected to force. So technically there was no assault. So here, in Chris's case, however, there is an unlawful act. So it could be assault in the brick flying through the air, producing in the victim, apprehension of immediate and unlawful personal violence, or criminal damage to the window or whatever. So there is assault or battery, and there's certainly enough to actually choose some sort of criminally unlawful act. And then, of course, in relation to Kima and Idris, where their property is set on fire, then this can be criminal damage or criminal damage by fire. So technically, it would be charged as arson, criminal damage by fire. So there's a specific formulation for that. So then the defendant's act, must be deliberate. It must be criminally unlawful, but it must also be dangerous and by an objective standard, so objectively dangerous in that it is likely to cause physical harm. And so this is confirmed by cases of Church and Newbury and Jones. Okay, so in Church, an act which must be such as all sober and reasonable people would inevitably recognise must subject the other person to at least the risk of some harm. Okay, albeit not serious harm. So this is quite a famous quotation. Lord Edmund Davis, very highly regarded judge, so it would be good to cite him. And Newbury and Jones confirmed the Church approach. The test of dangerousness was objective, and it depends on whether a reasonable person would recognise the risk of harm, and not on the foresight of the accused. So here, it looks like this, it's a criminally dangerous, act. And again, this case, JE and NE, where the defendants, you can see by the letters, they were juveniles, and so there was the argument that the reasonable person test should be modified by subjective features, but this was rejected. So, sort of age and mental capacity of the defendant. So rejected the argument that the objective test of dangerousness should take into account subjective factors such as age, mental capacity of the defendant, and held that the law strictly adheres to the well-established objective approach of Church and Newbury and Jones. Okay. And here, again, this is a confirmation that it's not necessary to prove that the reasonable person, a sober person, would have foreseen a particular form of harm. Just some harm would be sufficient. Okay, now in this case, JM and SM, then this quotation, it would be worth memorising or paraphrasing. So in our judgment, certainly since Church and Newbury, it has never been a requirement that the defendant personally foresee any specific harm at all, or that the reasonable bystander should recognise the precise form or sort of harm which did ensue. What matters is whether reasonable and sober people would recognise that the unlawful activities of the defendant inevitably subjected the victim or the deceased to the risk of some harm resulting from them. So that's, a good quotation. And then the next part would be, the causation, that the unlawful act caused the victim's death. Well, we've done all that bit already, so we can refer back to that point there. So then you would apply the law to the facts. And so in relation to Duquan and Idris and Kima, I think there are strong chances that Chris would be liable for unlawful and dangerous act manslaughter in those particular cases. Okay, so the other contentious area, Rob's pretty straightforward, Wendy. So here we need to recognize that Chris is driving his car. It's a lawful activity, but he's doing it in a very bad way. So it's not an unlawful and dangerous act. Well, he's driving at speed, which might be an unlawful act, but driving at speed or without due care and attention, those are strict liability offences. So it's thought that for constructive liability, then there needs to be a base offence, a base unlawful act that has mens rea, because in unlawful and dangerous act manslaughter, the mens rea for the offence is actually the mens rea for the unlawful act. So, Wendy's scenario, unlawful act manslaughter is not likely to provide a remedy. So we need to have a look at gross negligence manslaughter, so doing the driving in a very bad way. So we need to look at the leading case of Adamarco, so Lord Mackay in Adamarco, and then we haven't done this, so I'll just outline the basic requirements. So Adamarco, the Lord Mackay said there needed to be a duty of care, a breach of duty of care, and that the third point, that the breach was so gross or so bad in all the circumstances that it was deserving of the imposition of criminal liability, basically. So here we see that we've got a criminal offence, involuntary manslaughter, where a form of negligence, albeit very bad negligence, is a sufficient basis of criminal liability. So generally, negligence is not good enough for criminal liability. However, there are some exceptions. Negligence is not a mens rea, for example, because it's objective. So, generally, it's the traditional approach is that negligence is tort, and it's not good enough for criminal liability. But as I said, there are some notable exceptions, and this is the major one for a serious crime, gross negligence manslaughter. But of course, it has to be really bad negligence. Then other examples would be road traffic type offences. So like careless driving would be an offence of negligence, for example. But they're sort of more regulatory and also to promote public safety and road safety as a policy matter. Okay, back to the gross negligence manslaughter. So duty of care. So we go back to tort for the duty of care. So the trial judge would sort of direct the jury whether the scenario could be a duty of care. So if what's his name, Chris, is driving the car at speed, etc., and messing around trying to find his mobile phone, so can there be a duty of care in terms of tort? What would the duty of care be? Duty of care to whom, for example? To other road users. And what would your authority be in tort? What about the learner driver who was learning to drive on the pavement? And she collided with a lamppost and injured her driving instructor. Do you remember that case? Very good. Nettleship and Weston. Yeah, that's great. You remember from last year. Okay, so duty of care then, and then breach of a duty of care. Well, that's evidenced by the fact that he's answering his mobile phone, he's searching under the seat to find it, all that sort of thing. But the breach of duty of care has to be one that's quite severe. It's restricted in scope because it has to involve a risk of death. And then the third part, that the breach was so gross, the essence of the matter is whether, having regard to the risk of death involved, and this was said by Lord Mackay in Adamarco, the conduct of the defendant was so bad in all the circumstances as to amount to a criminal act or omission. In other words, deserving of the imposition of criminal liability. So this is not great, really, because, all right, duty of care, breach of duty of care, but was the breach so bad, so gross, that it's, deserving of the imposition of criminal liability? Well, we're asking ourselves, whether we've got a crime, and we've got a crime, whether, what was done was deserving of the imposition of criminal liability. So, this test is criticised as, pragmatic and not rational, really. Okay, so yeah, let's break this down and mention the case law that we might need to explore. So duty of care, Nettleship and Weston. So there are other cases, but this one, Nettleship and Weston, is the best one for us to use here. But of course, the case of Wacker about the lorry driver who had the illegal immigrants in his container lorry tells us that not all the tortious principles would necessarily apply. Miller is another good one to remember because that involves omission, whether creation of a hazardous situation, one which the defendant was bound to counteract through reasonable steps. So you remember he was the tramp or the homeless person who was in the empty house and was smoking a cigarette before he went to sleep on a mattress, and he woke up when he realised the mattress was on fire, but he didn't do anything about putting the fire out. He simply went to another room and went to sleep there, and so there was damage by fire to the room in the house. So he created this hazardous situation, one which he was bound to counteract, and by taking reasonable steps, and which it seemed he could have, and he failed to do so. So duty of care, breach of duty of care, and that it was reasonably foreseeable that the breach of the duty of care would give rise to a serious and obvious risk of death. So this serious obvious risk of death, this formulation was said in the case of Misra and Ruddling and in Rose. And then finally, that the breach of duty caused the victim's death. And then very finally, the fifth stage, that the circumstances of the breach of duty were so bad, so reprehensible in the circumstances, so as to justify the conclusion that what was done, that it amounted to gross negligence and required or was deserving of the imposition of criminal liability. Now, so I think our case would be pretty straightforward here because, obviously in driving in the way that Chris did, there was a risk of death. There are a few cases, Ruddling and Rose, which I'm not sure how very helpful they are, but they confirm this approach in Adamarko and Misra and Gurpal Singh, that that the reasonably prudent person must have foreseen a serious and obvious risk of death, not just any old injury or even serious injury, but a risk of death. And in Ruddling and Rose, the negligence was such that the Ruddling, who was a GP. Okay, just a moment. So these are the cases, but here, Ruddling, I've given you. So he was a GP who failed to treat failed to make a home visit to a 12-year-old boy. So the mother had rung up the doctor and said, "My boy's ill," and had outlined what was wrong with him. And the doctor had given advice over the phone, but didn't think it was necessary for him to attend the 12-year-old boy. But the 12-year-old boy, it turned out, was suffering disease, which your average GP, general practitioner, would not normally be expected to recognise. So that was the expert evidence in the case. So so Ruddling, had decided that the face-to-face visit was not necessary, and so the question was whether he recognized, um, a serious and obvious, sorry, not why he recognized, but whether the reasonable person would have recognized or foreseen a serious and obvious risk of death. So here, the mere possibility that an assessment might expose something life-threatening was not the same as, foreseeing an obvious risk of death. So here, the mere failure of the doctor to attend the boy could not provide the foundation of gross negligence manslaughter. So Ruddling was found not guilty in that case. That doesn't really help that much, but it just confirms the previous approach. So you could just use it to confirm what was said before in Adamarko, Gurpal Singh, and the Misra case. And Honey Rose is a similar case but this time the health professional was an optometrist, and she didn't examine the optical images, the x-rays, the retinal images that had been taken by her assistant previously properly, because if she had, she would have recognized that the patient was suffering from some sort of congestion and needed to be seen by a specialist. Okay, so you can have a look at those cases, and they would be cases to be familiar with in the exam because they're fairly recent, and an examiner might set a problem which is more focused on those cases that might have, say, a health professional in the scenario. So I put them there so that you can take a look at them and you can be a bit more up to date on things. Okay, so here, in assessing reasonable foreseeability of a serious and obvious risk of death, it's not appropriate to take into account whether the defendant would have known, but for the his or her breach of duty. So this was, Honey Rose was also not guilty in that respect. Okay, so probably we could leave Winterton, because Winterton was worse. It was, even if he didn't notice that the trench that was dug on site was, improperly dug, and he should have. So this was a case of sort of willful blindness, so that there was evidence of willful blindness in that particular case. So, but a reasonable person would have foreseen a serious and obvious risk of death in Winterton case because there was this great big trench and it just hadn't been dug properly. So when a workman went and worked in it, then the sides collapsed. It hadn't been, structured properly. So dangerous. Okay, so that's Wendy's situation. So apply to the facts there. Moving on to Rob. So we're looking at murder here because stamping on the head is at least intention to cause serious bodily harm. There's direct intention there. Now, note the limitation on the scope of the question. If you see this in the exam, you don't write about other things that are outside the scope of the question because there won't be any marks. But if that limitation was not there, then we would consider partial defences, etc. So I have a number of slides, afterwards, which you can look at, and it talks about partial defences. Okay, so I'll stop there. Any questions? Okay, so I'll move to the next room. Okay, thank you. Okay. Okay. Right. Good luck with equity and trusts.
Hello, Tracy. Hello, Tracy. You've left your microphone on in the other room. Oh. Hello, can everyone hear me okay? Yes, I don't know if you can hear the other lecturer. I've just actually asked the other lecturer because she's left her microphone on in this room. I don't know if you were hearing her as well. But anyway, if you can hear me, that's okay. All right, let's get started. So the three certainties. Now, there's always a question on this in the exam, and every year, I think basically every student does this question because it's quite easy. It's probably the easiest question on the exam paper, and it will be one of two. It will take one of two formats. Either it will be a draft will, whereby you have to advise the settlor whether he needs to make an amendment to the wording of his will, or it will be an actual will, whereby you will have to advise the executors of someone who's died. There's a real will, and advise the executors as to whether they can actually make the dispositions as per the will. But as I said, it's a relatively straightforward question. You'll see. After we've done this problem question, I'll go through another one with you, just take you through it, and you'll see that the themes get repeated. And examiners are not very creative. They use the same sort of phraseology, and the same sort of issues come up again and again. Okay, so we'll have a look at that. Right. Let's start off with the self-test questions. So the first one, can you create a valid express trust without using the word trust? Yes or no? No. I can. Sorry, my trust. I can hear you. Trust students. Can you hear? No, I can still hear you, Tracy. I can still hear you. Hang on a second. Hang on. Let me try. Hang on. I'll do it my end. Yeah, done. Okay. Sorry. I'm back. Right. The issue's been resolved. So yes, the answer is yes. The first one is the you can create a trust without using the word trust. And actually, even if you use the word trust, that's no guarantee that there will be a trust anyway. There is a case called the Kinloch and Secretary of State for India. Just because you use the word trust doesn't automatically mean that there will be a valid trust, that there will be a valid trust. So, but you don't have to use the word trust, because we know from the case of Paul and Constance, for example, in that case, the gentleman with his lover, he told her, orally declared a trust in that case, he told her that the money in this bank account is just as much yours as it is mine. So in that situation, there was a trust created. Maybe he didn't even know what a trust was, but what he did, what he said, amounted to a trust. It did amount to a trust. It did amount to a trust. So in that case, Paul and Constance, that's the one that you could cite as for being the authority for saying that you don't need to use the word trust. Remember, equity looks to the intent, not the form. Looks to the intent, not the form. So an intention is a question of construction. It's a question of interpretation. So has sufficient intention been manifested? And again, that could be in writing or it could be oral. Now, obviously, in an exam, you're going to get probably it's going to be in writing. They're going to be referring to a will, but it could also be oral. It could also be oral. Another important distinction you need to make and show the examiner when it comes to certainly certainty of intention is to let the examiner know that you understand the difference between imperative language and precatory language. Remember, precatory language, this is language that expresses a desire, a wish, or a hope. That is not sufficient. You need to use imperative language if you're going to create a trust. It needs to be imperative language, so that it's something that imposes an obligation, a legal obligation. And this is the case of Wright and Atkins, W-R-I-G-H-T, Wright and Atkins, Wright and Atkins. That's the imperative language must be used. All right, question 2, what is residue and is it a certain term? Yes, of course, residue is a certain term. Remember, residue is that which is left over after all the funeral expenses, testamentary expenses, debts, all legacies, annuities, costs of administration, etc., etc., etc. After everything's been paid out and paid off after you've died, whatever is left, that's the residue. Now that, of course, can't be ascertained right now, immediately, because you won't know, and even after, you won't know, and even your executor won't know immediately after you've died. But eventually, when everything's been paid off, whatever's left, that will be the residue. It's something that's not ascertained now, but it's something that's ascertainable. It can be worked out. So it is certain. It is certain. It is an amount of money, whatever's left over. Maybe nothing. It may be nothing at all left over as residue, but it could be something small, or it could actually end up being something rather large, because if one of the gifts has failed and it stays with the trust, or it results back to the trust, then whoever's the residuary beneficiary, then they're quids in. They're going to take the benefit of that, as we shall see later in the problem question. So it is a certain term. It is a certain term, residue. What is the test for? Actually, before we move on to question 3, just come to my mind now with regard to residue. Which case would you could you cite for the bulk of something? When it comes to there was the bulk of my residuary estate. That was a quote taken from a which case? Does anyone remember? The bulk of my residuary estate. Does anyone know? Can you type into the Q&A box or the chat box? The bulk of my residuary estate. Yes, Palmer and Simmons. Good. Palmer and Simmons. Again, the bulk of my residuary estate, the residuary estate part was fine. The residuary estate, that's fine. It was the problem was the bulk. What do we mean by bulk? That was not sufficiently certain. Okay. So You could say 50% of, or you could say, like a third of, whatever, but you can't say bulk. Bulk is anything from 51% to 99%. It's not sufficiently certain. Okay, question 3. Explain the certainty of objects tests for the following. Okay, fixed trusts. What's the certainty of objects test when it comes to fixed trusts? Can anyone tell me? What's the certainty of objects test? Yes, the complete list test, and that comes from the case of, which case would you cite as your authority for that? Yes, IRC and Broadway. IRC and Broadway. So it must be possible to identify every individual beneficiary. The trustee has to be able to ascertain who everyone is who's supposed to benefit. So there needs to be conceptual certainty and evidential certainty. Okay, that's for fixed trusts. What about discretionary trusts? What is the test when it comes to discretionary trusts? Yes, the any given individual test or any given person test. So it must be possible to say of any given individual that he is or is not within that class. So it must be conceptually, so there needs to be, is the any given person test. Any given person test. And this is the McPhail and Dalton. McPhail and Dalton is the case authority there. McPhail and Dalton. And then C, a series of individual gifts with a condition precedent. Now, I don't think you're going to get examined on this particular bit here, this series of gifts with a condition precedent. You should certainly know what they are, just in case, but I don't. The examination focuses on fixed trusts and the discretionary trusts. So, so a series of individual gifts with a condition precedent. Does anyone remember, or which is the relevant case for this? I talked about it in the lecture. When it comes to condition precedents, it's the Barlow's case. The Barlow's case. So the gift is valid for those who can prove that they satisfy the condition. Remember, in that case, is it's a lower standard of certainty than is required of trusts. Okay, so there is a difference there. There is a difference. When it comes to a series of gifts with a condition precedence. The Barlow's case, go and have a look at the PowerPoint slides or listen to that part of the lecture again when I talked about that in the context of condition precedence. Less likely to come up in an exam. More likely in this question it's going to be dealing with fixed trusts and discretionary trusts, okay, and gifts in the three certainties and gifts. Okay. But not usually with a condition precedent, not usually. Okay, what about 4? What's the difference between conceptual certainty and evidential certainty? What's the difference between those, conceptual certainty and evidential certainty? Well, remember, conceptual certainty, if there's conceptual uncertainty, then the trust will be void, okay, because conceptual certainty relates to the class of persons. If there's uncertainty, in the conceptual uncertainty, the trust is void. But evidential uncertainty will not defeat the trust. Evidential uncertainty relates to whether any particular individual can be proven to be a member of that class, whether any particular individual falls within that class. So does Mr. Johnson fall within that class? If there's evidential uncertainty as to that, well, that will not defeat the trust. Okay? It's only if there's conceptual uncertainty. It needs to be conceptually certain. Okay? It's very important, conceptual uncertainty. Remember in the Rebadens number 2, which is based on the same facts as McPhail and Dalton, because McPhail and Dalton, remember that was when they went to the House of Lords to determine what the test was. And then once they determined what the test was, the any given individual test, Once that was determined, it was then remitted back to the Court of Appeal, and then that was where that test set out in McPhail and Dalton was applied. And that was in Re Baden's number 2. And that's where the Lord Justices, the Court of Appeal, decided that dependence was conceptually certain and relatives was conceptually certain. Even though, as we mentioned in the lecture, remember there are 3 different reasonings as to what the certainty of relatives. So you've got Lord Justice Sachs, Lord Justice McGaw. They think it's a descendant of a common ancestor, whereas you've got Lord Justice Stamp thinking that it means next of kin. But anyway, either way, they all agreed that there was conceptual certainty there in the word relatives. And 5. What is meant by administrative unworkability? What is meant by administrative unworkability? Can someone tell me? What does that mean? What does it relate to, first of all? Which type of trust does it relate to? Usually where you'll see it in relation to, where you'll see it. Which type of trust does it relate to? Where we could have administrative unworkability. No, not fixed trust. No. Yes, discretionary trusts. And this was, in particular, you should note the case of ex parte West Yorkshire. In that case, there were just too many people, too many potential beneficiaries. In that case, in ex parte West Yorkshire, there were about 2.5 million potential beneficiaries. So the trust was just simply unworkable. And that was an easier way of dealing with the case, rather than having to go and consider the conceptual certainty of that. Because in that case, remember, it was and I quote, for the benefit of any or all or some of the inhabitants of the county of West Yorkshire. Any or all or some of the inhabitants of the county of West Yorkshire. Now, what does it mean to be an inhabitant of West Yorkshire? What does that actually mean? That seems, you could argue that's conceptually uncertain, because what does an inhabitant mean? Can you say with precisely what that means? Is it someone who lives there permanently? Is it someone who lives there for more than 6 months a year? Does it relate to? Would it cover people who are on holiday there? What if somebody owns a house in West Yorkshire, but they live in London, or vice versa? Does that, they rent a property, or that's their voting constituency, or that's where they pay the council tax rates? What does it mean to be an inhabitant? Maybe the courts could narrow that down and determine what is meant, but it can make it a little bit conceptually uncertain, I would argue, what is meant by inhabitant. And again, look out for problem questions. They may use the word inhabitant, they may use the word resident as well. Again, what is meant by that? So inhabitants of the county of West Yorkshire. That's arguably conceptually uncertain, arguably. But anyway, the court didn't need to deal with that and concern itself with it, because they could just simply say that there was just too many people, and it was administratively unworkable. Okay, right. By the way, what about if that discretionary trust? Just another bit of a revision for you. What's another way of saying discretionary trust? Do you remember? Another way, which is quite confusing, But just to make it clear, because when you're reading this, sometimes some judgments it can be quite confusing. What's another way of saying a discretionary trust? Yes, good. Trust power. A trust power. That's very confusing. Okay, when you talk of trust powers, but when you see trust power, it actually means discretionary trust. Okay? So, what's the difference then between a trust power and a fiduciary power? What's the difference between a discretionary trust and a fiduciary power? What's the difference between the two? Does anyone remember? Important distinction you need to draw, and it's not always clear. I mean, even in McPhail and Dalton, all the way up there, there was disagreement between the courts as it went through the various stages of the court hierarchy. The different courts were saying decided. Some thought it was a fixed trust, fiduciary power, and then when it eventually got to the House of Lords, they said no, this is a discretionary trust. But it's not always clear the difference between the two. But what is at least in theory, what's the difference between the two? Someone said obligation to properly consider whether or not to exercise. Well, what do you mean by that? That's not just the difference. There's something more than that. Something more fundamental. Yes, when it comes to discretionary trust, or a trust power, if you want to call it that, the trustee is obliged to actually make the distribution. He's actually obligated to make the distribution of the property. Now, he can choose to whom he makes it and in what amount. That's discretionary. That's the discretionary part. But he must make an appointment, as they say, the technical way of saying it. He must make a distribution. But with a fiduciary power, there's no need to even do that. There is no requirement to actually make a distribution at all. And if you do decide to make one, well, again, you can decide who it goes to and in what amount. But you don't have to actually dispose of the property. You don't actually have to distribute the property if it's a fiduciary power. The only thing you have an obligation to do is an obligation to consider using. I mean, how anyone could prove that you didn't consider it? Well, that's another issue. But still, theoretically, you have an obligation to consider the distribution, whether to distribute the property, but you don't actually have to distribute it. And as I said earlier to you, for exam purposes, they tend not to. I mean, you should certainly know the difference between a fiduciary power and a discretionary trust. But for exam purposes, you're most likely going to be tested on discretionary trusts. So that should be your focus there. McPhail and Dalton is the test when it comes to certainty of objects. And it's the same test actually as fiduciary powers, and that comes from the case of the Gulbenkian's case. It's the same test as well for certainty of objects. But discretionary trust is the one that the most likely you're going to get tested on. Okay, right. Let's delve straight into the problem question then. Let's have a look at the problem question. Now, remember, when you're answering a problem question in any area of law, follow the ILAC formula: issue, law, application, conclusion. Okay, this is what examiners are looking for. These are the elements they're looking for in your answer. Have you identified the issues correctly? Have you stated the relevant law? Have you applied that law to the facts? And have you reached an appropriate conclusion? Again, when it comes to conclusions, make sure you come down on one side of the fence. Don't say, well, maybe not. Don't do that. Always come down on one side of the fence. But don't come down too firmly. What do I mean by that? Don't say, for example, this trust will definitely be void, or this will definitely be valid. You can't say that. No, even the best lawyer in the world cannot predict the court. What the court's going to say, and that would be negligent of you anyway to advise a client, that they get, to guarantee something, because you can't guarantee. What you can say and what you should say is something like, it is likely that, or it is very likely that, if you think so, or unlikely or very unlikely that. That's the better way of phrasing it. But you can make clear your view, and so long as you back it up with authority, you can cite the relevant case law, then you will get your marks. Even if the examiner disagrees with you, so long as you can back it up, you will get credit for that. Okay, so that's important. But do come down on one side of it. Advise the client. That's what you mean. To advise them, So tell them, do they have a good chance or not? Make it, but you don't need to be so absolutist in your, and you shouldn't be. You should just say likely or very likely, unlikely, very unlikely. Okay. Now let's have a look what we've got here. So. Right, clause A in the, where are we? Here we are. Okay, Josie. So Josie's died, and she's left a valid homemade will. A valid will. So there's nothing, considering whether the formality to, the formalities in the Wills Act, etc. You don't need to do that. Okay, just take it as written. It's valid. Okay, so don't need to get bogged down with any of that. It's a valid will. So let's look at A then. A. The majority of my shares in ABC Limited are to go to my sister Rose. Okay. What do we have here then? Do we have intention here? Is there certainty of intention? What could you point to? What's the language? Remember, intention is a matter of interpretation, a matter of construction. It's a matter of interpreting the words used. Okay, so look at the words used. What tells us that there is or is not certainty of intention here? Is there certainty of intention? An intention to make this gift, the gift of the shares? Is there an intention? What do you think? You can type into the Q&A box if you like, or the chat box. Is there certainty of intention here? Yes, are to go to. Okay, this is yes, it's mandatory. It's imperative. Is the word used? It's imperative language here. It's imperative wording. It's the case authority Wright and Atkins. You can quote Wright and Atkins. It's this wording are to go to. That's like a command. Okay, that's imperative. So that's okay. Objects, certainty of objects, that's no problem. We know Sister Rose, okay, that's no problem. The problem is with the subject matter. Why? Why is the problem? Why is the problem with the subject matter? What's the issue here? Why is the wording problematic? Exactly, majority. What does majority mean here? The majority of my shares. So if Josie had 100 shares, well, majority is anything from 51 to 99. Okay, so that's what is meant by that. That's too uncertain. And the case authority you would cite would be, by analogy, a similar sort of situation. Which case authority would you cite for this? We mentioned it earlier. What is it similar to? There's a case that an examiner would expect to see here. Bulk, yes, similar to bulk, which is which case? Comes from which case? Palmer and Simmons, good. Yes, Palmer and Simmons, the bulk of my residuary estate. The residuary estate part is fine, but it's the bulk. What do you mean by bulk? And that's what you could quote here. So if we follow Palmer and Simmons, if the court decides to follow Palmer and Simmons, then this gift will fail. And the consequence then is that this intended gift will be considered to be nugatory. Okay, it doesn't go anywhere. It's just nugatory. You can use that word. Okay, nugatory. So it just fails. It's nugatory. So our conclusion then is that this intended gift will not take effect, and so the shares will simply remain in the estate. They don't go anywhere. They remain in the estate, and who will benefit then? Who will benefit? Who's going to benefit from this? No, not Rose. The estate of Josie, yes. So who's going to benefit? The beneficiary of the residuary estate, yes. Which is who? Phil, yes. So it won't go anywhere. It will just remain within the estate, and it will go to whoever's the residuary beneficiary. Okay, good. All right. Let's look at B. My brothers Lewis and Dylan are to have one each of my rental apartments in Manchester. Lewis can have first choice. Is there an intention here? An intention? Do we have intention? Is an intention to create the gift? What's the language used to show that, to back that up? Are to. Are to have, yes. Are to have. Are to have. Okay, so we've got the intention. We've got certainty of objects. Yeah, that's no problem. Yeah, Lewis and Dylan. Yeah, no problem. Well, the problem comes from what? The subject matter, but why? Why is that problematic? Why is the subject matter problematic here? Yeah, I mean, we don't forget. I mean, forget. Why is it problematic? Why? Okay, then yeah. Why aren't you sure which one will get the upon? What's the issue here? Why is that a problem? Why don't we know which one it refers to? Why don't we know? Why don't we know? It says Lewis can have first choice, so that means Dylan gets whatever Lewis doesn't want, doesn't he? What's the problem? Let's say there's two apartments. There's two apartments, one each. Okay, there are two apartments. Lewis gets one, Dylan gets the other one, and Lewis gets first choice. So why is it problematic? He gets first choice of the apartments. There's two apartments. Lewis can choose first which one he wants, and the other one will go to Dylan. What's the problem here? Surely that's certain, isn't it? She wants Lewis to have first choice, and then he chooses one, and whichever one is remaining left, that one is to go to Dylan. What's the problem with that? Where's the problem? There is a problem, but why? Why is there a problem? There is a problem here. A big problem. On the face of it, there's no problem. But when we look at the facts, we have a problem. Why is it uncertain to choose which apartment? Why? Lewis has first choice. He can choose first out of the two. And whichever's left goes to Dylan. That's what it says. Why? Well, what? So that, on the face of it, looks certain, doesn't it? Where does the uncertainty come from? No, he can't. He can't choose one and then argue wants the other. No, he can choose, make his choice, and then. No, let's assume she's just got two apartments because she's saying I think it's clear from the context there are to have one each. So that assumes that there's two because there's one for Dylan, one for Lewis, one each. On the face of it, that looks fine. Well, where does the problem come from? Come on, I can't believe everyone's missed this. It's obvious. It's staring you in the face. Something very simple. Yes, he died. Lewis has died before Josie. Okay, Lewis has already died. He's died before he's made the choice, before the will takes effect. He's died. Look at the end of the last, second to last sentence at the bottom of that question. Lewis died a week before Josie. So he hasn't made a choice. So when it comes to giving the property to Dylan, well, which apartment of those two is he supposed to have? Because the apartment that Dylan was supposed to have, that was to be determined by, well, whatever was left over when Lewis made his choice. So Lewis would get to choose out of the two apartments, and whatever's the remaining, then Dylan would get. But Lewis is dead. He never made that choice. So we don't know which one Dylan was supposed to have, because the mechanism for determining that never, well, Lewis died. It never happened. The choice never happened. Okay? And it's reminiscent of which case? Which case is this reminiscent of? Involving two sisters. Does anyone remember the case? It's reminiscent of which case? Boyce and Boyce. Remember? The Boyce case. Boyce and Boyce. Boyce and Boyce. So this is a case you can quote. And this is very similar to the facts of Boyce and Boyce. You know, because the one sister was to have a choice, and the other property was to go to the other sister after that choice was made. But the sister who had the choice died before she made the choice. So Lewis didn't make the choice because he died a week before this will took effect. He died a week before Josie died. So if we follow Boyce and Boyce, then the subject matter of this gift to Dylan is uncertain. And so the gift would fail. and it would remain part of the estate still. It would remain part of the estate and pass to the residuary beneficiary, which would be Phil. Now, if you want to score a few bonus points here, you could critique this decision. You could say that Boyce and Boyce is a bit outdated now. It seems to be unfair in this case. And based on the equitable maxim that equity looks to the intent, then maybe maybe the gift should be valid. Because equity looks to the intent. Josie intended a gift to Dylan, to both Dylan and Lewis, but all she was doing was just saying Lewis can have first choice. But presumably, if Lewis died, then she wouldn't mind that Dylan gets the choice. Okay, so if we apply base it on the if we mention the equitable maxim that equity looks to the intent, then based on that, I think we could try and argue that this should still be valid. Especially because the courts have, in other cases, taken a more flexible approach to subject matter, like in the case of Golais, the Golais case, remember, where the court thought a reasonable income was a sufficiently certain term. Why? Because the court thought that they, as the court, could make that decision as to what is reasonable, what is a reasonable income. Because the courts make decisions on reasonableness on a daily basis. It's a question of facts, case by case, but they do make a decision on what's reasonable. So what's a reasonable income for Mr. X may not be a reasonable income for Mr. Y, for example. But they can determine that based on the facts of the case. So based on that flexible approach, it seems, taken in some cases, you could try and argue that maybe the court should not follow Boyce and Boyce here because of, Josie clearly intended Dylan to benefit from one of those apartments. All she was doing is just giving Lewis first choice. And now Lewis has died, he never made that choice. Is that fair to deprive Dylan of his intended gift? Okay. Yeah, you could just mention it as a side note, get a couple of bonus marks for that perhaps. But if we follow Boyce and Boyce, then no, the gift would fail and it would remain part of the estate. And so Phil, as the residuary beneficiary, will benefit. Someone's just asked, is it okay to argue that the word can is not an absolute term? Lewis can choose it first, but it's not necessary for him to do it. Well, you could, because it's saying that Lewis can have first. It's up to Lewis then. He can make that decision. He doesn't have to. Because he says she could have said Lewis shall have first choice, which would have been clearer. But even by saying Lewis can have first choice, he still never had the chance to make that choice. So he still didn't have. He never had the chance to decide whether or not he wanted first choice. Maybe he would have said to Dylan, "Oh no, you can have first choice." Okay. So under current wording, it would have been possible to allow Dylan to decide. That would have been Lewis's choice as to whether to let Dylan have the thing, and he never had the opportunity of doing that because he died before the will took effect. So either way, it would still fail based on Boyce and Boyce. Okay, good. Let's have a look at C then. C. £100,000 to my brother Dylan, but he should leave anything that is left over that he doesn't want at his death to his daughter Claire. Okay. Now, objects, fine. Certainty of objects, doesn't seem to be a problem there. The problem seems to be with subject matter and intention. It's very similar to the case of Sprange and Barnard. This arrangement is very, very similar to Sprange and Barnard. Okay, this arrangement. Okay, which was basically, in that case, that was construed to be a gift, which was subject to a trust obligation. Okay, so it was a gift with a trust obligation attached to it. in Strange and Barnard. Now, when we're talking about subject matter, it needs to be clear what the property as a whole is, but also the beneficial interest. So there are two aspects here. Now, subject matter, the £100,000, that's fine. We know that. That's clear. There's no issue there. The problem is how much of that is to be held on trust for Claire. That's the problematic part. Anything that is left over that he doesn't want. I mean, first of all, how would you know he doesn't want it? Because if he's just died suddenly, how would you know he doesn't want it? But even if, forgetting that for a moment, the fact is anything that is left over that he doesn't want, that is too vague. It's not certain enough. What does that actually mean? So the amount of money that's to be left over, left on trust for Claire, is uncertain. So that would fail on the basis of Strange and Barnard. Okay, that trust would fail. Now, this is where you can show the examiner that you really know this area of law well, because you would now quote the case of the case of Hancock and Watson, known as the rule in Hancock and Watson, which basically says that where there is an intention to create a gift with a trust attached to it, if that trust fails, then the initial donee, the person who received the gift, they will take it absolutely. So when you've got a gift that's subject to a trust, and the trust part of it fails, because of uncertainty of subject matter, for example, then based on the rule in Hancock and Watson, the person who received it as a gift first, they will take it absolutely. So in this particular instance here, Dylan will take the £100,000 absolutely. The trust element fails. Okay, there's no trust in favour of Claire. Dylan will just take it as a gift, £100,000. Okay, it's the rule in Hancock and Watson. Okay, I'll come back to that a little later because it's relevant to the next problem question that I'll take you through. Okay, D. £200,000 to Lewis and Dylan on trust for loyal fans of favourite band The Rolling Stones to distribute as they shall, in their absolute discretion, think fit. Now, what's the problem here? Do we have is there imperative language here? Do we have imperative language? Do we have intention, first of all? And if so, quote it. Where is it? The shall comes with regard to the discretion part, but where do we have? We need to show certainty of intention to create a trust, not what to do within it, but to create a trust. So where's the language? Where's the language to show that this was intended as a trust? To distribute, yes. To distribute, underline that, to distribute. That's imperative. So that suggests a trust because it's to you to do something. Now, what type of trust is this, by the way? What type of trust is this? Discretionary trust, yes, correct. Why is it not a fiduciary power? Can someone tell me why this is not a fiduciary power? Why is this not a fiduciary power? Is obliged to exercise the discretion. Someone said, why? You put a question mark there, but is he then? Well, no, the shall part comes with their absolute discretion, But you also have an absolute discretion with the fiduciary power when it comes to distribution. When it comes to in what as they think, when it comes to the actual amounts you give out. But what makes this a fiduciary? What makes this a discretionary trust and not a fiduciary power? Not the shall so much, because that could apply to both in the way it's on this wording. Something that was mentioned earlier. Yes, is to distribute. To distribute. Using the phrase "to distribute," that suggests we have a discretionary trust there, because it suggests that there's an obligation on making the distribution. Remember earlier when I said about the difference between discretionary trust and fiduciary power. Discretionary trust is there is an obligation to make the distribution of the property. The discretion part comes as to whom you make it and in what amount. But with the fiduciary power, in a fiduciary power situation, there's no obligation to make a distribution. There's no obligation to do that. If they decide to make the distribution, well, that's up to them. If they do, then they have discretion to whom they make it and in what amount. But they don't actually have to make the distribution. The only thing they have to do is to consider making it. But they don't actually have to make a distribution. But when it comes to a discretionary trust, otherwise known as a trust power, confusingly, but when it comes to a discretionary trust, there is an obligation to make the distribution. You have to. And by using the words to distribute, that suggests that we're dealing with a discretionary trust here. Discretionary trust. Okay. So, what's the test for certainty of objects when it comes to discretionary trusts? What's the test? What's the test? Certainty of objects. Discretionary trust. Yes, the any given individual test or any given person test. Yes. Which case does that come from? Very important case. An examiner would definitely be looking for this. Yes, MacPhail and Dalton. MacPhail and Dalton. So can it be said with certainty whether any particular person is or is not within this class? Okay, MacPhail and Dalton. Now remember, MacPhail and Dalton, it was a House of Lords decision as to the test, and then it was that case was remitted back to the Court of Appeal, and then it became known as Re-Baden's number 2, and that deals with how that test was applied to those facts, how that test was applied to the facts of that case, and then whether it met the any given individual test. We looked at dependents and relatives, etc. Re-Baden's number 2. So you can have a discussion here for extra marks. The examiner would like to see, that you appreciate the difference between conceptual certainty and evidential certainty. So a discussion of Re-Baden's number 2 would be useful. And if you go back to the lecture and the slides we looked at, go back and look online. The lecture when I talked about the different approaches taken by the courts in Re-Baden number 2 with regard to conceptual certainty, and with regard to evidential certainty. So go revisit that part of the lecture. Remember, now if we apply that here, do you think we have conceptual certainty here? Is there conceptual? What are the objects? What are the objects here? What are the objects? Who are the objects? in this case, who are the objects? Loyal fans of the Rolling Stones. Do you think that is conceptually certain? No. Yeah, I don't either. I think that's a bit dodgy. What on earth do you mean by a loyal fan? How on earth? What is a loyal fan? Is that someone who owns every single one, has bought every single one of their albums? Is it someone who attends every single one of their concerts? Or someone who attends more than half of their concerts per year? You know, what does it mean to be a loyal fan of the Rolling Stones? Do you have to someone who buys all the T-shirts and hats or whatever? You know, what does it mean to be a loyal fan of the Rolling Stones? That seems a little conceptually uncertain, I would say. If it is conceptually uncertain, of course, that would defeat the trust altogether. That would absolutely defeat the trust if it's conceptually uncertain. But even if we got over that hurdle and there was conceptual certainty, what's the next problem? What's another big problem here? What's another big problem? Even if we got over the conceptual certainty issue, which I think will be problematic anyway, but even if we could get over that, what's the problem here? Yes, it would be administratively unworkable. It's likely to fail because it's administratively unworkable. There are just too many potential beneficiaries. Even if you could define what is meant by loyal fans of the Rolling Stones, they're a huge band, as you know, a huge music group. They have millions of fans. So there are just too many. Okay, so it would just be administrative. They're all over the world, too many, and all spread out all across the world. They're just too many. It would be administratively unworkable. So this is where you could quote the ex parte West Yorkshire case. Okay, the district auditor, where you can just call it the ex parte West Yorkshire. The examiner will know what you mean. Ex parte West Yorkshire case. So it's likely to fail for administrative unworkability. Now, just going back to the conceptual certainty part here, when we talk, I think that's problematic. If you want some bonus marks in an exam, you could mention briefly how the courts have attempted to resolve conceptual uncertainty. Again, go back to the lecture. You know, that part of the lecture when I was talking about when you have like a third-party arbiter, or the re-Tux case. What are the different mechanisms? You could briefly discuss, very briefly. Don't go off on a tangent, but briefly discuss how the courts have tried to resolve the issues of conceptual uncertainty. That would be worthy of a few bonus marks for sure. Okay, so look at how there's attempts to resolve the conceptual uncertainty. So here then, in this case, our conclusion then would be that the property would likely result back to the estate. It will result back to the estate, and of course, it form part of the residuary estate. So Phil would benefit here. Phil would benefit. Okay. And then we have E. E. The residue of my estate is left to my husband Phil in full confidence that he will provide a reasonable income for our daughter Anna. What's the problem here? Yes, in full confidence. Again, you see how unimaginative the examiners are with their language here. This is language used in an actual real case. In the Rhea Adams case, Rhea Adams and Kensington Vestry. So yes, in full confidence that's not imperative language. That is precatory. that's like saying, I leave it to him knowing, in full confidence that he will do this. I'm sure he will. I'm sure he will. I trust that he will do this. I've got full confidence. I'm quite confident that he's going to do this. Okay? That is not imperative. That's not an obligation. That's not an obligation. That's more of a moral pressure at the most. At most. It's not imperative language. And remember, you need imperative language. Wright and Atkins. Okay? Imperative language. You can't use precatory language. So intention is problematic here. Okay? Intention is problematic. You need to make it clear that the person is holding that property. The person you're giving the property to, you need to make it clear that they are holding it on trust for someone else. That needs to be clear, that they must hold it on trust for someone else. So based on cases like Re Adams, another case, Lamb and Eames is another one. Based on that, that's using the phrase in full confidence is not enough. And if you want some bonus marks, you could mention the case of Comiskey, the case of Comiskey, and in that case, that talked about when you're construing these individual clauses, you have to construe them, you have to interpret them in the context of the will as a whole. Okay, in the context of the will as a whole. But even if you do that, it still seems doubtful here. Even if you look at the rest of all the other dispositions, I still don't think we can save this. Okay, but again, if you want a bonus mark, mention the Comiskey case. The courts, when they're construing the words in these dispositions, these various dispositions, they have to look at the will as a whole, in the context of the will as a whole. But even if we read clause E in the context of the rest of what we've got here, in the context of the other dispositions, I still don't think we can save it. I still think this is doubtful that this could be have the requisite imperativeness to it. Okay, it's not imperative. Okay, the language used. Now you could also mention reasonable income. Is that certain? Reasonable income? Is that a problem? Is that a problem, do you think? Is reasonable income a problem? Why? Yes, the Gollay's decision. Okay, reasonable income. If the court decides to follow the Gollay's case, there was a very flexible approach taken there to the subject matter, and reasonable income the court thought was something that the court was capable of determining. So that was okay. But again, make sure the examiner is aware that that reasonable income would not be a problem here, and neither would residue. Residue is fine. Residue is fine. We know that the residue of my estate. That's a certain term. So is reasonable income. The problem is with regard to intention here. So that would likely mean that the trust is defeated, and therefore Phil will take the residue absolutely. He will take it absolutely. So all that residue will go to Phil. So you can see Phil's done. Beneficiary will benefit is if anything, any of those gifts fail, or the trust fails, any of the dispositions fail, then they remain in the residuary estate, or they'll result back to the residuary estate. So you've done pretty well if you're a residuary beneficiary such as Phil in all this. Okay, good. Right. If you have any questions, you can ask me at the end. We'll go back, but I want to move on to another problem question, because again, the more you do of these, the more you can see how unimaginative the examiners actually are, and it'll help you in your preparations for answering a question, which is, again, by far, I would suggest the easiest question on the exam paper. So let's have a look at this one. This is based on the practice questions that I posted onto Sol. This is question B. We looked at question A, but let's look at question B. Question B. Okay, so this is available on Sol, so you can find it there. Christian. Now here we've got a draft will. The previous question we've looked at, that was an actual will, and we were advising the executors. Here, this is a draft will. This is the other alternative that you could be asked in an exam. It'll be a draft will, and the person writing the will wants your advice on whether it's clear enough, whether it will actually be effective, how he intends it to be effective, or whether there are any problems, whether it needs redrafting and amending. So just have a quick scan of that for 1 minute. Just have a quick look at the read of that, and then we'll discuss it. Okay. So we're advising Christian now, his draft will. Let's look at the first disposition here. £100,000 to my most special friend Ian, but he should leave anything that is left over at his death that he feels that he does not want or need to our mutual friend Hazel. Oh, here we go again. You see, very similar to wording to the previous question. So what do we have here? What's the problematic word, first of all, when it comes to intention? What's the problematic word that you might want to underline and you might want to get him to amend? What's the problematic word? In relation to intention, certainty of intention, what's the problematic word in disposition A? Good, yes, should. Should. Now, what is meant by that? Should. That's not a very... Should sounds... is that precatory or is it imperative? If you should do something, is that really... Is that more of a moral obligation rather than a legal obligation? You should do something. You should give up your seat on the MTR for an old person. You should, but there's a moral obligation. There's no legal obligation. You don't have to, but you should. There's no, so should is problematic there, and so I would certainly advise him to replace that word with what? What would be a better word than should? Shall. Yes, that's the much better. Well, that's a legalistic word. You could say will, but it's not as elegant in this context. I would say shall. Shall is legalistic and it's very clear. You shall. That's more obligatory. It's imperative. So I'd say replace the word should with shall. And the question is then, do we have the rest of this then? Anything that is left over at his death that he feels that he does not want or need. So is this an outright gift, or is it a trust which is attached to a gift? Well, again, this is reminiscent of the case of Sprange and Barnard. Sprange and Barnard. And in that case, remember, the lady left to her husband this property, and I quote, "for his sole use, and at his death, the remaining part of what is left that he does not want to be divided between the beneficiaries." Okay. Now, in that case, in Strange and Barnard, it was decided that the court thought that interpreted that wording as meaning a gift, not a trust. The gift was the dominant intention. Okay. So it looks like a gift, the dominant intention. It's the dominant intention here. Because what do we mean by that? We've got a problem here with subject matter. Okay, subject matter. Oh, and if you want if you want bonus marks in the exam and impress the examiner, you can mention the case of, let me write it in the box for you here. I've mentioned it in lectures as well, I'm sure. The Missouri Bank case, the Missouri Bank case, where you just one sentence, you can just say, based on the Missouri Bank case, the uncertainty as to subject matter can cast doubt on the settler's intention as well. So if whenever you come across uncertainty of subject matter, it can also cast doubt on whether there was certainty of intention, whether there was actually an intention to create the trust or make a gift. Okay, that's the Missouri Bank case, Missouri Bank and Raynor. So uncertainty of subject matter can also suggest uncertainty when it comes to intention as well. That maybe there was no intention to create a trust. Now, if a trust in favour of Hazel then fails, then what rule can we apply? Does anyone remember? What rule can we apply? If that trust in favour of Hazel fails, we can apply the rule in, anyone remember? Where property's been left to a beneficiary as a gift, but subject to a trust. If that trust fails, then we can apply the rule in good. Hancock and Watson, the rule in Hancock and Watson. And that would mean then the beneficiary, the initial beneficiary, takes the property absolutely. So in this case, then Ian would take the property absolutely. So if the trust in favour of Hazel fails, which it probably would on these facts, then the rule in Hancock and Watson would apply and Ian will take the property absolutely. So look out for this wording. This is common wording that often comes up. This in disposition A. It's just like in the previous question and the previous problem question. Anything that's left over that he feels he doesn't want or his needs, something like that. That's very similar to Strange and Barnard. And in that, it's uncertain as to subject matter, so the trust element will fail. So whoever received that gift that was supposedly subject to a trust, whoever received that gift, they will take it absolutely. They will take it absolutely. The trust element of it falls away, it fails, it falls away. So whoever had the gift, in this case Ian, then Ian will take absolutely. So our advice then to Christian, in conclusion, would be use imperative wording. So use shall rather than should, and make it clear what property is to be held on trust. If you want to make a trust in favour of Hale, be clear what property. What's the subject matter? Okay. All right. B. The majority of my collection of theatre awards to my uncle Calvin to hold on trust for my cousin Louisa until she attains the age of 25. Problem here, again, the word majority. Yes, majority. You would quote which case would you quote? It's similar to Palmer and Simmons. Good. Palmer and Simmons that use the word bulk. It's the same. So, for example, if he had 10 theatre awards, then majority could be 6, 7, 8, or 9. So which is it? There's uncertainty there. So there's no gift here. There's no gift. There's no resulting trust. It's simply void. Because we don't know what the actual subject matter is, what the property is. So our advice on this this one, it's quite straightforward, would simply be to clarify the number of awards. Okay, so that was quite easy. So this one's just a subject matter issue. What about C? All of my shares in Phantom PLC are to go to my elder sister, Patricia, hoping that she will look after our younger sister, Sabrina. What's the problem here? Hoping. Good. Hoping is clearly precatory. That's not imperative. That's a precatory language. It's a moral obligation at the most. A moral pressure at the most. There's no legal obligation there. Hoping that. Okay, so again, circle the word hoping, because again, examiners use this is the kind of thing examiners use again and again. You know, hoping that she will look after. So that's not good enough. That's it. Hoping that it's similar to the Rhea Adams case. Remember, Rhea Adams and Kensington Vestry, where they said in full confidence that she will do what is right. So in full confidence, it's the same sort of thing. Hoping. Again, if you want some extra credit, mention the Comiskey case. You know, which says that you should look at the context of the will as a whole. Look at the words used as a whole when construing them, when interpreting the words. But even if we do that, even if we look at this wording in the context of the whole, all of the other dispositions, it still seems precatory. There doesn't seem to be an obligation there. So in this case, I would say that Patricia would take this as a gift, absolutely. Okay, Patricia would take this as a gift, absolutely. Okay, so this is a matter of intention. Okay. D. £65,000 to Daniel on trust to be distributed amongst such residents of Wales as he shall in his absolute discretion think fit. Again, what type of trust is this? What type of trust is this? Discretionary trust, yes, good. And we can tell it's a discretionary trust. Well, it seems to be a discretionary trust rather than a fiduciary power, because it says to be distributed. Okay, so it's like an obligation to distribute. So we know with fiduciary powers there's no obligation to distribute, but here it seems there is an obligation to distribute. So it would be most likely this will be interpreted as being a discretionary trust. Okay, discretionary trust. Okay, and certainty of objects for discretionary trusts is which case? It's the McPhail-Dalton case, any given person test or any given individual test. So residents of Wales, someone's mentioned. Yes, residents of Wales, conceptually certain? Again, there's a question mark over that. What does it mean to be a resident of Wales? A resident is a bit like inhabitant. A resident, inhabitant. What does it mean? Someone who lives there permanently? Someone who lives there more than 6 months a year? Is it someone who's got, that's their voting constituency where they pay council tax? What does it mean to be a resident? That could be, that's a bit uncertain, you could argue. And if it's considered to be conceptually uncertain, that's the end of the story. I mean, that's game over. That's the trust will fail. Remember, evidential certainty is not a problem. That's not a problem. That does not defeat the trust. You could have that little distinct, again, that's an opportunity there to show the examiner that you understand the difference between conceptual uncertainty and evidential uncertainty, and you can discuss the Rebadens number 2. Okay, that's to show the examiner that you know your stuff. Okay, and you know that evidential uncertainty is not fatal at all, and the difference between the evidential uncertainty and conceptual uncertainty. But the problem is with what? Even if we can get over the conceptual uncertainty part, even if we can get over that hurdle, the problem is what? Yes, administrative unworkability. You see how these things are repeated? They come up again and again. If you look at the past papers, again, you see the common theme. So I do strongly recommend you to go and look at the past papers for this subject, and you'll see that with this question in particular, it's the same sort of thing coming up again and again. Okay, so administrative unworkability. Okay. and again, this is where you quote the ex parte West Yorkshire case. And the population of Wales, I can tell you, is more than 3 million people population. So again, it's administratively unworkable. So it's likely to fail because of this. Okay, because of this. So the trustees would basically be holding this property on. Does anyone know what kind of trust they'll be holding it on in this if it fails? They'll be holding it on resulting trust for the estate. Okay, they'll be holding on resulting trust. We'll look at resulting trusts a bit more later on in the course. But they'll be holding on resulting trust for the estate because it will fail. So our advice to Christian would be, first of all, make clear what you mean by resident, so you can define that. Make clear. Does it mean someone who's lived in that area for more than 10 years, consistently for more than 10 years, or someone who was born there, or someone who has got their they pay local council tax there. Make it clear what you mean by resident. But even more important here is reduce the number of potential beneficiaries. So rather than saying Wales, why not narrow it down to a village in Wales, for example? That would make it easier to deal with. Okay? A village with a few hundred people would be more manageable than having the whole country, which is the whole jurisdiction there, which is 3 million people. 3 million people. Now, just for a moment before we move on to the next one, why would it be important then to distinguish with regard to D? Why is it important that we distinguish between a fiduciary power and a discretionary trust? Why would that be important? Based on what we've just talked about, why is it important we make that distinction here? Well, that is the distinction, the obligation. No, it's important because, remember, I alluded to this in the lecture, if you remember, administrative unworkability is not a problem for fiduciary powers. If this was a fiduciary power, the administrative unworkability would not be a problem. The conceptual certainty could still be a problem, based on the Gulbenkian's case. That could still be a problem. And that's the same. Remember, conceptual uncertainty is the same test as it is for discretionary trust. It's the same test. But administrative unworkability would not be an issue. Why? Can anyone tell me why? I alluded to this in the lecture. Do you remember why I suggested that administrative unworkability would not be a problem in the context of fiduciary powers? Technically, why it would be no problem. Can anyone remember? Well, technically it wouldn't be, because the trustees simply don't have to make a choice at all. So if they found it administrative, but they don't have to make a choice at all. If it's a discretionary trust, though, they do have to make a choice. They do have to distribute. But if it's a fiduciary power, they don't. So it's not a problem. They just don't have to distribute it. The only problem that could come up in the context of a fiduciary power is, does anyone know? The only thing that could potentially defeat the fiduciary power would be something else. Look at your notes. Capriciousness. Check your capriciousness, where there's been no meaningful justification for the selection of the beneficiaries. So whereby, we're in that situation. But again, that's the concept that for exam purposes, you're most likely going to be, you are going to be tested on discretionary trusts rather than fiduciary powers. But if you can make clear that distinction, that you show the examiner that you understand the difference between a discretionary trust and a fiduciary power, then you are in for bonus marks there. Someone's asked, so in the exam, when discussing discretionary trust, do we need to point out that clause D does not relate it to a fiduciary power explicitly. Well, it's up to you. You don't have to, but I think it would be good to say something like, based on the language used, to be distributed, this shows that this is a trust power or discretionary trust rather than a fiduciary power because a distribution actually has to be made. Simple as that, just one sentence. Straight away, the examiner knows that you understand the difference between the two. So if you didn't mention it, fiduciary power, you certainly wouldn't lose marks, but I think if you want to get a couple of bonus marks, why not? Make it clear that you understand the difference between the two. Because if it said may be distributed amongst, then that would be a fiduciary power. There's no obligation. But it says to be distributed. You're highlighting to the examiner that you understand the difference. And not a lot of students will know that difference. So, okay, good. Right. E now. We're on to E. E. Okay. Now, what's the issue here with E? The residue of my estate, including my entire rental property portfolio, is to go to my friend Diane, but she must ensure that Ian enjoys a reasonable income from my properties. What's the problem here? It's a bit of a trick question, actually, because I don't think there is a problem here. I don't think there is a problem. And usually each one of the dispositions will be problematic, but not always. In this case, no. But again, this is for you to show the examiner that you can see that there's no problem, because what you can say in this case, that residue is a certain term. That's no problem there. Reasonable income is okay. You can talk about the Golay's case. That the court seems willing to make an objective assessment. The Golay's case. So I don't think this one's very problematic. It might be better. We could say, you might want to consider specifying the income rather than just saying reasonable income, just in case. So it might be better for him to do that. But as it stands, it would be okay. It would be okay as it stands. All right. So again, when you're doing go and look at the past papers, or while it's fresh in your mind, even over the weekend, just have a look at the past papers and look at I think it's usually the first question on the paper. I think it is first or second question, something like that. Have a look at that, and you'll see the dispositions are all very similar. The similar theme. Just get used to the language used by the examiner, and just underline and highlight and circle those particular words that I've drawn your attention to, because they come up again and again and again. It's the same sort of issues I dealt with. Okay, does anyone have any questions? If you do, you can ask me now. Otherwise, I'll leave it there for this evening. Okay, so if you've got a question, you can type it in now. Otherwise, all right. Okay, all right then. Well, I'll see. I think we're meeting on either virtually or in person on Saturday for the next lecture. Okay, so I'll see you in the next lecture. We'll be finishing off formalities. We're looking at Constitution on Saturday. Constitution. Okay. All right. Have a good evening. What's left of it. Over and out.